Good morning, everybody. Bright and early for the Karen Reed Supreme Court oral argument on the double jeopardy claims. So it's about to get underway soon. I've got the live stream getting all ready. I'm watching it. I'll add it to the screen so you can all see that I'm looking at the same thing that you are. Just waiting for it to get underway. And in the meantime, we'll just hang out together and drink some coffee. Now, I guess I should talk a little bit about what the issues are in front of the court. Obviously, the main one is the double jeopardy issue. That's the overriding ultimate issue here. But that comes down to a few different parts, which we've explained already a number of times in our previous videos about this specific topic, about double jeopardy. That is the fact, and I think this is what a lot of the oral argument and the questions from the justices are going to be focused on, the fact that there was no objection. I think that that is going to be one of the main sticking points and one of the big questions that they're going to be asking the attorneys representing Karen Reed. Why was there no objection? Was there really no chance for an objection? On top of that, there's the case of Fuentes. Fuentes, we spoke about in some of our other cases, some of our other videos about this specific topic. Fuentes is a very interesting case, which I think was wrongly decided. And if this was me, just because of the legal scholar in me wants to see the correct law applied, I would be arguing to the justices, and I'm assuming that they may bring this up. I think this would be a fair point to bring up the Fuentes case and ask questions about why this case is not similar to the Fuentes case, if not worse. Now, remember, what happened in Fuentes is that there was actually a mistrial declared over an objection. There was an objection lodged to not have that mistrial declared. And in Fuentes, what happened was the judge didn't really do any sort of careful analysis, careful consideration of any alternatives, and the mistrial was upheld and was not considered double jeopardy. Now, I think that was absolutely wrongly decided, and I think it conflicts with a number of other Massachusetts Supreme Court cases and Court of Appeals cases. So if this was me, just the legal scholar would ask the Supreme Court to overrule Fuentes and hold that Fuentes was wrongly decided. So I think that these may be some of the questions that are going to be asked. Let me just recognize some people. Millie Rivera, good morning to you. Participation Trophy Wife, good morning. Lorna McKenzie, good to see you again. We spent a lot of time yesterday on the live chat together, the live stream that we had of the trial, Craig Lewis trial. And good afternoon to Erica V23. It's almost 2 p.m. here in the UK. Okay, well, afternoon to you. I know one thing is that we're probably all happy that we don't have to hear about election talk. I think we're kind of all done with that. We can hopefully move on with our lives now, get back to regular business. And obviously following these important cases is important. So kind of hopefully get our focus off of the elections for a minute. And hopefully those ads will stop, those non-stop ads where you can't get away from. Hopefully those will all stop. Get back to regular life again. Good morning, Sunshine Mitch. Yes, you also were with us yesterday, so day 2 with me. That's great. Let's spend some more time together. Good morning, Asha Vreden from the Netherlands. And good morning to Maui Swift. Nice to see you again. We spent a lot of time yesterday as well together on the live that we live streamed the Craig Lewis trial. Very interesting trial. Morning, Kim Yakowski. Hi, BC. Please consider doing a video on Rudy Giuliani's court troubles. He has a judgment against him but hasn't surrendered the items required. What happens now? Okay, I'll have to take a look at that. Morning, Blurry Lights. AIM. Learn more about Double Jeopardy. How? Rendezvous on Brother Counsel's channel. We did a lot on Double Jeopardy. We did a bunch of videos really analyzing all of the relevant law. All right, here we go. All right, guys, here we go.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston with and before the Commonwealth, draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session. Please be seated.
Okay, good morning. Madam Clerk?
SJC 13663, Commonwealth versus Karen Reed.
Attorney Weinberg.
Good morning, Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant Karen Reed. Today's appeal goes to the core issues regarding double jeopardy protections that safeguard defendants, in this case, Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent. And we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury reached a unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first.
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have a basis to.
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof
Sure.
that a 5th juror contacted the defense. A juror who could have been one of the 5 or could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that that voir dire would result in proof that there was a final and binding.
Mr. Weinberg, you jump all the way to acquittal, correct?
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous decision.
Well, you cite Taylor, which is the case in Quincy where the judge, basically there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error.
Yes.
That case is an opposite to what this situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you said.
I'm telling you, you're wasting your time if you're arguing that's an acquittal. I've said this so many times, and now he's wasting his time with the Supreme Court arguing that it's an acquittal. It's not an acquittal. You can argue that the mistrial was improper. That's what his argument should focus on. And now he's just wasting his time because he decided to argue acquittal.
Say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declaration.
Well, that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than in many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible.
Right, we've spoken about this. We said that the only cases that allow you to call the jury back, at least that's straight out in the case law, is when there's racial bias or if there's jury tampering, outside extraneous influences on the jury. That's the only time that the case law has said that you can bring back the jury. So the question is, neither that happened here. So what are you asking us to do? Are you asking us, and this is what I said before, are you asking us really to extend that to situations like this, which is a ridiculous outcome and conclusion, and which is why he just wasted 5 minutes on this argument and he's only got 10 left, and it's really the weakest of the arguments. It's just a mistake.
Rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was
Doesn't Fiddler caution to not inquire into to intrude into the sanctity of the deliberative process as well?
it does.
Absent this extraneous influence.
It
But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations, and that a carefully set of questions preceded by an instruction.
Okay, what he's supposed to do at this point is say, Your Honor, I'd like to move on to the more meritorious argument. I just wanted to make that argument for the completeness of the arguments, but I want to move on to the more meritorious ones instead of wasting his time doing this.
Seek to impeach the written communication by the foreperson, correct?
I'm sorry,
You
Judge.
seek to impeach the written communication of the foreperson, correct?
I wouldn't. I would say that the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges. But count 2 by itself, read vertically, had multiple charges. Horizontally, there were 3 separate counts. There
Oh
was
my gosh.
ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration of mistrial. And I contest that there were at least 3 viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
Really, you've got an exhausted jury writing this very eloquent message saying, we haven't been, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the words.
But again, there's no inkling of what's going to happen.
And I've told you also, arguing about the charges, all charges, this is all weak arguments. You got to hammer home your strongest argument. You got to make sure you do that. When you see the clock, you see that time rolling down, you say, Your Honors, maybe I'm going to concede on this issue. I want to move on to the more meritorious arguments. And he's not doing that, and his time is just ticking away.
Error to declare mistrial.
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Didn't the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
There we go.
The judge discharged the jury. Once the judge thanked them and said that the case is over, the failure to make an objection, it was futile. It
What
was
about,
unnecessary.
what about the case of Commonwealth versus Enid Brown, where the jury was sent, the jury goofed, essentially. There was a miscommunication between the clerk and, you know the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And had the jurors that assigned or that made these representations starting the very day after the announcement of the mistrial, if they had told the
But
judge,
I guess the point I'm asking, Mr. Weinberg, is there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may, after the discharge of the jury, I'll talk to you later, as most judges do. The lawyers then talk about a conference, scheduling conference and timing of it.
Yes.
Wasn't there an opportunity at that point for the attorney to object and say, this is what should happen, these are my thoughts?
And that's exactly what I've been saying all along. That was the time, that was the opportunity that they should have objected. And in fact, if this justice really wanted to hammer home the point, he would say that, and that's what happened in Fuentes. That's exactly what happened in Fuentes. The jury was dismissed, and then that's when the lawyer put the objection on the record. So there's definitely that opportunity to be given here, and they didn't utilize that opportunity to make an objection.
in part based on the failure to make an objection.
And I think we cut you off when you said there were three things that could have happened. Could you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said, bring the jury in. The jury comes in seconds later, 30 seconds if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question.
You're not answering the question. The question is, wasn't there an opportunity to object?
Which is illuminated by the jury declarations that there were two
Why-
ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes two previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tui Rodriguez charge to be given.
Yes.
I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks.
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note and the third note
Yes.
that would indicate any less of an impasse between the first, second, and third notes.
Yes, what happened is that.
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours, subject to a TUI instruction, which is designed to encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all.
So again, she's going back now on his argument that really they wanted to acquit her on charge 2, and you don't see that at all in the notes. And again, this comes back to when you make the argument, which is a little ridiculous, which I've explained already ad nauseum. When you make the argument that this was really an acquittal, then you see how silly that ends up looking. So better off to keep saying anytime this issue comes up, even if you want to bring it up, which I wouldn't have. If you want to bring up this issue, say, Your Honor, you know what? I'm conceding on this issue. I really want to talk about the main issue here, which is the not having an opportunity to object, which is also not the greatest argument, as we've explained also, but it's better than this because now they're just wasting time on this.
Matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the 3 notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority? Why would that be the critical moment?
Because before that, there's at least an impasse on one count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the three alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The reporter's notes.
At the moment of the declaration of the mistrial, what suggested in the notes, the three notes, that there was any agreement as to any of the three charges?
Facially, they said
Nothing.
they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tui Rodriguez. And the prosecutor said, not yet. And she said, yes, no, not yet. And then there was the second note where, again, they report that they're in an impasse quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez. And the defense counsel says, yes, go ahead and give Tui Rodriguez. And she considers that alternative and gives the Tui Rodriguez instruction.
Yes.
Now we have the third note. We've really tried on all the charges. Some of us agreed that beyond a reasonable doubt, that the elements of each of the charges have been established. Some of us do not. And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time.
There's no way he has any time left.
It sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. If you want a mistrial, you ask for
So
one.
your rule would be that anytime there's more than one charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you at an impasse as to count 1? Are you at an impasse as to count 2? As to count 3? That's the rule?
And the answer to this question is no, Your Honor. I'm not saying that they must do that. All I'm simply saying is that it should be discussed. That's all. I'm asking that the judge should discuss the different options and give careful consideration to the options, which is what the case law requires. So let's see how he answers this question.
It was a may, Mr. Weinberg.
The may was in the rule. The reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation.
So he's actually arguing for must. Oh my gosh, I can't.
Particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in.
In the ordinary case, the foreperson will say, we've got a verdict on counts 1 and 7, and we seal them, and then we continue on, and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples, but 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Wendlandt, and I guess to me as well in the court, is that that is not discretionary.
My argument is that given the core values of double jeopardy,
You've just lost it. They're even helping him, saying, don't make this argument. Are you really arguing that it's must? The rule says may, and you're not going to win with must. You don't need to change the rule in order to win. All you need to say is that there has to be careful consideration of other ways to go about this mistrial. There's There has to be careful to other options. That's all. It just has to be done. It doesn't, you don't have to give separate verdicts. The rule doesn't say that. The rule says the judge may inquire, but there was no discussion about it. That's how you win this. And
I think
not
it's,
happening.
268-34C. That's a third alternative. Here, the problem is the record doesn't reflect the trial judge's consideration.
As a matter of
Of these
fact, were there
alternatives.
3 separate verdict forms?
There was actually more than 3 verdict forms because the verdicts on count 2 had multiple,
But
they had 3
so
different
count 1 and 3, were there separate verdict forms for those?
I believe there was separate forms, but there was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, are you done? So I'd like to ask, how are you, the judge says she can't ask the questions that you're saying she could without interjecting herself in deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instructions given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations. Can you tell us how?
Yes.
Why? How would she do that? She doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, and what the votes were. Just tell me what your.
This is how you answer that question, okay? This is, if I'm there, this is how I answer this question. Well, Your Honor, according to Judge Cannoni, actually Rule 27B, which says that a judge may ask about separate verdicts, she actually is of the opinion that a judge can never ask for separate verdicts. And that's exactly what you just read, that she can't even ask those questions because it's too coercive. So actually, Judge Cannoni is the one who's asking for a new rule in Rule of Criminal Procedure 27B. She wants 27B to say a judge may never ask that question. So that's obviously incorrect, Your Honor. There are ways to do it. That's why the rule contemplated that there's ways to do it in a way that's not coercive. And you can just simply ask, are there different verdicts on the different charges? You're not coercing. You're not asking them for the deliberative process. You're just simply asking them for a verdict. That's how you answer that question. Let's see how he answers it.
Was it ever reconsidered or rediscussed?
That question, was it final? Isn't that gonna, the jury can change its mind, right?
Could, but there's no way.
But isn't that going to result in asking that type of question? When you say final, if you don't get your way on 2, is it final?
Was it ever reconsidered? My contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror who they served for months says to anybody, to the court, to the clerk, to the court officers, to the prosecutor.
Well,
Wait,
they also don't write in saying we agree with the other 5 or anything to that effect. They're silent, as their deliberations are supposed to be silent, right? See?
But it's an almost unprecedented meeting of a burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what juror D says. We went to the bus and says, no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that what was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's your best authority to say that It was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafker's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time.
So, and the answer to the question, and I understand the question, in the Bluford case, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
Okay, guys,
That's
I'm going
my
to stay on
point.
afterwards to discuss
If
more.
you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, we allow a court to ask about mental processes. Was there communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Miss Reed was acquitted by those jurors, and we should have the opportunity, or if not acquitted, we contend a unanimous vote. We should have the opportunity to have Judge Cannone conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with an
Right, but when
external
it's an
source.
extraneous source,
And by the way, guys, I'm going to stay on a little bit afterwards to discuss, any other questions that come up. But I'm afraid that if I pause it, we're going to miss some of the oral argument. So,
to go directly to the jury deliberations.
And I would contend they go to the results of the deliberations. They do not require a judge to ask, why did you vote not guilty? What led you to vote not
So
guilty?
the question
Did you
asked
vote
to
not guilty?
juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count 2. We were not yet done.
And that would reflect two
It's a
things.
jury deliberations, right?
That would reflect that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Cannone, if conducted, that was my vote. It was not guilty.
It
We never
seem-
reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? We have a long line of jurisprudence that says we presume that the jury follows the instructions.
And there is cases where when mistakes are made by jurors, where they don't fill out the verdict slip accurately. The
That's not
case,
this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity.
Okay,
and the
before you shift back to that,
Yep.
what's the best case, best federal case? Because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing after? What's if we want to go back and read one case that's
It's
going to do what you want us to do, what's the closest case?
It's actually a Mississippi case. I think it's named Martin versus
That's a-
State that the amici
That's a
brief
state court
brought
case,
us
right?
to.
It's-
They read
It's
the
a state
newspaper.
court case, right?
It is.
Any federal cases? Because again, this is a federal constitutional issue.
You know, there are cases where jurors correct
No,
verdicts.
no federal case
This is,
that has the, you're asking us to direct Judge Canoni to do this. I just would be helpful if you have a federal example that we can turn to, because
Remember what I always talk about? If you have a case that really helps you, that you should say it. If you don't have a case, then you just lost. So really, his argument is that there are some federal cases that talk about racial bias or jury tampering, and you just want to extend that. So then what you're asking really is, okay, those cases, you should say those cases, and we're asking you to extend the holdings in those cases to this scenario in front of us. But he's not even citing a case at all. If you don't cite a case at all, you lost.
we can turn
there's-
to, for example.
nor has the prosecutor come up with any case to the contrary. This showing by this jury,
Doesn't matter.
it's not going to open the floodgates for post voir dire.
Well,
This is
actually,
a-
that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, that's not really what happened.
Remember, this is one of the points that I brought out, is that where do you draw the line? That's exactly what she's saying. Where do you draw the line? You're saying we should extend it to this. So tell me, where exactly do we draw the line? At what scenario do we draw the line and say we're not going to call the jury back when this happens, and we are going to call when this happens? Racial bias, we understand. Jury tampering, we understand. At what point do we call the jury back? Tell us the guidelines.
Unequivocal, unconditional. They said we reached a final verdict of not guilty. And I
So the
urged
jurors submitted affidavits?
the jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules. It's Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B or would have asked the judge to ask the jury whether to.
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have two extremely experienced trial lawyers.
Here we
No
go.
one in that room would ever think potentially a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving the Tui Rodriguez.
Yep, we spoke about this also. These are experienced attorneys. They know exactly what's coming down the road. So if you're going to object, get ready to object fast.
Beyond the table is that a mistrial, And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
But let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer, there's an impasse, bring the jury in. If your honors, would accept the audio video that again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to.
The judge said that they're at an impasse. Call the jury in. Right then, if you're an experienced attorney like Yanetta, you know after a Tui Rodriguez charge and after they're again at an impasse, they cannot deliberate anymore. It's either a mistrial or you better come up with some other alternatives. And that didn't
Trial
happen.
experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections.
Wait,
So
the judge said they're at an impasse, bring in the jury?
bring in the jury and you can actually hear a door open.
Okay,
So
and you have 30 seconds to object?
but you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the
You
jury
can say,
can't
Your
hear.
Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in
But
the
they
note.
did know that the jury had reported to her that they were at an impasse.
They were in an impasse, bring the jury in. Yes, that was possible, but to
What was
extinguish,
possible?
to ask to go to the bench, but
Yes.
this
And
court
did that
has-
happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign, they want to re-prosecute.
It's your
somebody
duty to object.
after
What
a
are you talking-
mistrial, to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have this more of an obligation in double.
They don't have the obligation to object for you. I'm sorry. This is just, it's just really, really getting more off the rails as we keep going down this path.
A defense lawyer, when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard, they don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial,
After
correct?
a careful consideration
Mhm.
of all alternatives and after giving.
So
the
that may
defense-
explain why perhaps the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted a
Mr.
verdict.
Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives TUI,
Yep.
and then the jury comes back and says, we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than just declare a mistrial?
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Yes.
Right, and in the face of that,
In the
you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect were carefully considered, including, is your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was.
Again,
And
at
in
July 1.
in the statutes, again, is a may, correct?
The statute says 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option
But
not
the
considered.
careful consideration is basically all that has gone on as far as the length of deliberations, the number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made
No, the answer to that is no. That's not careful consideration for other options. The case law is that you have to carefully consider other options then to declare a mistrial. Show me where that was done. That's how you argue back.
being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it a life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you. Okay, Attorney Schillinger.
Good morning, Your Honors. May it please the court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining.
By the way, they do keep saying a brother because they're referring to brother counsel and not me, but that's how we refer to each other in court.
A mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
The judge did inform counsel that the jury was at an impasse, and I would argue at this point, it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given Tui Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges or either of the lesser included offenses, they would have necessarily had to find that the victim did cause, or excuse me, the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more.
Well, rather than speculate what the defendant.
Yeah, that's speculation.
Let me ask you about what happened. Did the judge have either the discretion or an obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. It perhaps is a matter of.
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what a judge or a jury may do.
Exactly.
So it's not inherently coercive. If the judge has the discretion, it can't be coercive,
It's,
correct?
well, no, it's a matter of discretion and then consider the factors that inform the exercise of that discretion. And that's what the judge did consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further,
He was going all right, but until he's didn't agree on that. It's not coercive. Judge Canoni was just wrong about that. Sorry, Your Honors, she was wrong about that.
forced to continue deliberating, any verdict they return wouldn't be a just verdict. It'd be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits, now 4 or 5 days of deliberations. They've returned.
Can you tell both of these people to contact me afterwards, and I'm going to tell them how to make an oral argument in the Supreme Court?
They are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why, when we talk about what potentially we could do short of saying, mistrial, let's start again?
Yeah, certainly, Your Honor. And I think, in hindsight, seeing, the quote unquote remarkable turnaround of the defendant's position, would it have been better? Would it have been preferable for the judge to take that extra step? Perhaps, and another judge might have done that.
Good.
But here, given the progression up to the third note, and in particular, given the defendant's response to each of those two prior notes, I think the judge could reasonably conclude the jury is at an impasse. There is a manifest necessity for a mistrial. There is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
But you can't.
The answer to that question is you may be right that you didn't carefully consider all the other options, but the law requires the defense to object, and they didn't object. That is the answer to that question.
I get manifest, you may have manifest necessity, but I don't see how you can get consent when they haven't been consulted in any way.
They were consulted in response to the first two.
They don't have to be
notes.
consulted.
What
They
was
just
the
have to make an
defendant's
objection.
response to those notes? It was to argue in favor of due and thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from, that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunities to object. They could have objected while waiting for the jury to enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's at an impasse. They could have brought the issue up again during the scheduling conference after the jury was excused to the jury room. And even after that, they still could have brought it up. And we cited in our brief Fuentes as an example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room. And at that point, the judge did still consider counsel's arguments.
All right, very good. He brought Fuentes up. That's exactly what I would have told him to do. So at least he's getting it right in that way.
And I think given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
You might have, I know it probably is in your brief, but what's your best case for that?
This case is closer to Pellegrin, Your Honor, and very different than Horrigan.
Mm-hmm.
So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Horrigan is an example of that. Judge comes in, abruptly announces, trial judge is unable to preside, I'm declaring a mistrial. There was no indication there that, the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared to not.
How do you know the defendant is advocating for a mistrial as opposed to pushing a verdict?
Because, Your Honor, not just what they argue, but what they argue.
Because Tui, there's two results of Tui. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say that they're advocating for a mistrial, they could have been just as well advocating the jury for that final push. As the Tui Rodriguez instruction says, you need to check yourself. One side has the burden of proof. It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Again, and that's not a good argument to say that they were pushing for a mistrial. The argument is that the case law is clear. What case fit? Say Pellegrine, every single case, Your Honor, that ever discussed about consent says that if you do not object, that equals consent. Never in any of the cases does it say that the judge has to ask the attorneys. The attorneys have a duty to object. If they don't object, that's consent. It's clear, black and white in many cases.
The Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time. Let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, "We believe there's been sufficient time." Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing that they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered, and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a Tui instruction, correct?
Yes, they asked for that as well in response to both notes, Your Honor.
Do you need consent in order to win?
No, Your Honor, there was manifest necessity for the declaration of a mistrial here.
And so absent the consent, we can just, you think the manifest necessity existed?
Yes, I don't think that the judge abused her discretion in declaring a mistrial for manifest necessity based on the jury deadlock in this case for the reasons that we have discussed and were discussed with my brother.
But counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues, where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in the record here, where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of declaring a mistrial. Is there no calculus here that says that perhaps there could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively think about this. And perhaps we can all come to.
And the answer to this is that, well, Your Honor, if you want to overrule Fuentes, that's up to you. But that's what Fuentes exactly says. The judge didn't do any of that in Fuentes, and still the Supreme Court upheld Fuentes as a good decision. So if Your Honor wants to overrule Fuentes, that's up to you. But that's what the case law is. That's the binding case law in Massachusetts right now.
For the judge to do something more. I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps. But the judge's determination here, which is owed some deference, if not an abuse of discretion, was not outside the range of reasonable outcomes given the jury's notes and these other considerations, Your Honor.
You don't think it would have been coercive to say, come on, jury. I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs. But did you reach a verdict on count one?
I do think that would be extremely coercive, Your Honor, yes. And I would point the court to footnote 5 in Ray versus Commonwealth, where this court said or noted there may be a prevailing practice among federal courts about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry, but that is not the prevailing practice here in Massachusetts and is not an encouraged practice, particularly because of the risk of coercion.
I take it Rule 27 doesn't, there's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind, right?
Correct.
But so I see your point on the note is so compelling that they've worked this to the end. But then the problem comes when we get this new information that's somewhat inconsistent with that I mean, the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
And I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already.
I get that point. I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have some follow-up obligation here. Is there no obligation whatsoever, I guess, is what?
No, and we argued below, actually, Your Honor, that it's not reliable or competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
Accepts.
By the way, who's paying Yannetti and Jackson to be there? There's no need for them to be there. I hope Karen doesn't have to pay for them to be there.
Right? So she doesn't say they're unreliable, but rather accepts their reliability and then concludes that nonetheless that she can't inquire here without invading deliberations. It's different from reliability. She's given up the reliability point, right? She's made a finding that I accept for these purposes that those 4 jurors or 5 jurors
Correct.
are credible, right? So it's not a reliability issue that you can rely on, right?
Correct, but the judge also correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged. They've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
Well, the request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
But not to get into their
Well,
deliberations.
that's a separate matter. You said that, you can't bring this jury back. You can bring them back for post-verdict inquiry.
Well, it's
I-
one.
Under the guidance of Fiddler, et cetera, right?
It's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury back to essentially construct a
And that
verdict that was never
what Mr.
returned.
Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
it's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of 2 competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it can.
The answer is, well, Your Honor, you said yourself that where would you draw the line? I mean, anytime a juror comes back afterwards a few months later and says, hey, by the way, the verdict wasn't actually that, we actually all acquitted. I mean, where exactly do you draw the line? I mean, that's what Your Honor yourself said, asked to my brother counsel.
Charged now for more than 4 months and has been subject to extraneous influence.
Okay, that's not me. Looks like the live stream paused for a minute.
Your Honor, is not
There we
a
go.
reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is, it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence.
But
So it's,
our post-verdict inquiry is guided, and we always say to the jurors, and we tell the trial judges, just, you have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited question. And the limited question posed by the defense, and I think in the ACLU brief, is, did you reach a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
I don't know that that was the specific question they proposed, but I understand,
Whatever.
I take your Honor's point.
Yeah, I mean, however
Yeah.
they phrase it, it's a limited yes/no question.
Yes, and my point is that that's an artificial inquiry, or take, for example,
But we asked,
Did
do you reach, have you reached a verdict? That in and of itself is a standard question, right? That can't be crossing the line, right? Or is it?
no, but again, I want to
Don't argue
the
this.
point that was raised earlier, which is, imagine a juror had tentatively agreed to find not guilty on a particular charge, but that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else. I just want a yes or no. It doesn't give that juror any opportunity to explain
Oh,
their
no.
agreement was tentative at that point. And so it's an artificial exercise to say,
Is that what Bluford, is that Justice George asked your brother counsel about Bluford? Is Bluford
Hey, you called my
the
name.
answer for you, that that's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it, it's only in lesser included that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
would argue that it is, and I'd actually take it one step farther, which is, not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been the product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty. So even if, like counsel wants to argue, this was a final vote, this was a final decision, you still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bluford, or is the different?
To characterize
Mhm.
counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form. Although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement, where it said, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bluford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Bluford limited to lesser included, or is Bluford broader than a lesser included opinion?
I don't read it that way, Your Honor. No, I read it as the general proposition that there are multiple charges, whether they're lesser included or not. Jurors remain free to go back and revisit a prior vote.
Well, that's
In fact,
true.
I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless, the jury remained free to go back and revisit a prior vote because that's what jurors do. And it wasn't inconsistent with the instructions. I want to emphasize one other point, which is, at most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short circuit the verdict requirement can rely merely on such a snapshot. And it's important because it protects defendants too. You could imagine a different scenario where juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless your honors have any other questions, Commonwealth would ask the defendant's petition be denied.
Okay, thank you very much.
Court, all rise, please.
All right, well, that's it. Really, I have a lot of thoughts about this. And probably going to have to do a breakdown of this in another video. But if anybody has any questions now with respect to what happened today, happy to look over those questions. I think it comes down again, like what we said always. We've been going around talking about to argue for an acquittal, silly. The only argument you have is that the mistrial that was declared was inappropriate because careful consideration wasn't given to the alternatives, which is what the case law requires. However, as we've explained a number of times on the channel, you don't even get to the manifest necessity prong unless you have some sort of an objection. If there was no consent, then you move on to manifest necessity. But if there's consent, if the defense consented to the mistrial, there's nothing to talk about. This is all one big waste of time. So really, that's where the focus should be. Was there consent or not? And the case law is abundantly clear that if you don't object, that is not consent. And I think this could have been stressed a lot stronger by the prosecution. And again, I don't take sides. I'm just looking at the law. I do the research. I look at the law. I leave my emotions out of it. Do I think Karen Reed should have been acquitted? Yes. There's not enough evidence to convict her. Nevertheless, specifically with this issue, whether there was consent for the mistrial, it is clear from the case law that this would be considered consent. You know why? Because every single attorney, even if you're not as experienced as Alan Jackson and David Yannetti, you would have known that after the third note that the jury sent out that they're at an impasse, and the judge, and there was a Tui Rodriguez charge already read, which means that they cannot go deliberate again. So if you know the very basics of criminal procedure in Massachusetts, you know a mistrial is coming down the road, and therefore you have business objecting. If you don't object, that equals consent. And that really is the strongest argument for the state. The state could have also, they did mention a little bit about, obviously this was not an acquittal. The verdict has to be read in open court. This is not elevating form over substance. This is just the very basics of what a verdict is. You have to actually read the verdict. It has to be recorded. It has to be in open court. You can't just come back a few months later and say, you know what? I forgot to tell you really what our verdict was, and this is what our verdict was. So that part obviously is going nowhere in a hurry. I've said this. I've maintained this from the beginning till the end. I'm sure once we get an opinion, they're going to spend a little bit of time on explaining why this was not an acquittal, and the charges, all that wasted time on those arguments is going nowhere. The only argument is that there was no manifest necessity. And then when they get into Judge Cannoni, specifically what she said in her order, and the state's always trying to back up whatever Judge Cannoni said, and the defense is trying to always disregard everything that Judge Cannoni said, you don't have to do that to win. Okay, if you want to win, you could say, especially for the state, Judge Cannoni may have made a mistake with respect to whether her asking if they have a verdict on the other charges is coercive. You're right, she may have made a mistake, but it doesn't matter. It doesn't really matter at this point, because at the end of the day, they did not object, and therefore there was consent to this mistrial, which means you don't even get into manifest necessity. And in fact, even when you get into manifest necessity, the Fuentes case says straight out, straightforward, even when there is an objection, and there was zero You look at the Fuentes case, there was zero consideration, careful consideration of alternatives. And still the Fuentes case said that it was not considered double jeopardy. The mistrial was proper. So, and then from the state's position, what you always want to do if you're the state is you want to say, Your Honors, if you want to overrule Fuentes, that's your prerogative. You can discuss that. But the law in Massachusetts right now is what Fuentes says it is. Now, if I'm the defense, if I'm Weinberg, then I say, Your Honors, the other cases, the other Supreme Court cases like Stewart, say straight out that Fuentes is wrong. There is a very clear contradiction between the Supreme Court decisions. And therefore, it is important for you to correct what the standard is in Massachusetts and overrule Fuentes. That is what you should do. But if you're the state, you say Fuentes is the law. That's the most recent case. And that's where it says that there was still considered a manifest necessity, even though the judge in Fuentes didn't do anything different than the Judge Canoni. Thank you very much, Kim Hastings, for the support here. Thanks, BC, for your expert analysis as usual. Elizabeth Hughes, how long till the court decides? I think I read somewhere 150 or 180 days, generally speaking, for an opinion to come out. So we could be looking at that. By the way, there was a motion filed it was a joint motion by Karen Reed and the defense team and the state, the new prosecutor, requesting the adjournment of the trial. So right now the trial is scheduled for January, I think it's 27th. They actually moved the trial now to, they didn't move the trial, but they're asking the judge, they're moving the court. It's a motion to adjourn the trial into April because the state wants to bring in some experts. Now it seems that there's going to be some biomechanical experts coming in, which is exactly what the state needs. If the state wants to win this case, and I've been saying this from the beginning, once I heard those biomechanical experts from ARCA, if the state wants any sort of chance to win their case, and by the way, the civil case would work the same way. If you want any chance to win, you've got to get a biomechanical expert, just like those ARCA experts, to say that actually John O'Keefe's injuries and the damage to the car are consistent with Karen Reed hitting him with the car. So that is what the state needs. And it seems that the state is trying to do that. They're trying to get some biomechanical experts, and they have to conduct an analysis, and they have to do all this, all this testing, and they have to figure this out, put all the equations together and write a report. So that is what this new prosecutor is doing, which is exactly what you should be doing if you want to convict Karen Reed. Now, again, even if you have those experts and it's just experts versus experts, does that get you beyond a reasonable doubt? I mean, those ARCA experts were just from a different world. I mean, there's such experts that even if you get other experts on the same level to disagree with them, so then it's 50-50. Let's just call it 50-50. Is that beyond a reasonable doubt? That's not beyond a reasonable doubt. So even though the state is definitely trying to do their job in this case, any reasonable juror, and I really wonder how these other jurors, after hearing those experts, felt that was not beyond a reasonable doubt. I really like to know that. But I think to any attorney that was watching this, once those experts testified, it was game over. It was really game over. She should not have been convicted. So, Maui Swift, what's your thoughts on their decision? I'm assuming you're asking the thoughts on the decision of the Supreme Court, what the Supreme Court is going to decide. I'm assuming that's what you mean. And what I've said from the beginning until today is that if you follow the law, and if you don't understand the law because you've been watching the other channels and they don't actually look into the law and research the law, if you go back and look at some of my videos where I actually really do a deep dive in all of the case law that has to do with this specific issue, if you follow the law in this case, there is no double jeopardy claim here. This is all just a big waste of time and money. And I feel bad for Karen Reed. She would have called me, I would have told her to save her money on this. But if the judges actually follow the law in this case, then there's not going to be a double jeopardy claim. And the mistrial was appropriate. It was declared appropriately, and there was consent to it by the defense. And therefore, there's going to be a new trial on all the charges. So that is my call, because that's what the case law says. That is straight out in the law. And I walked you through all of this. If you haven't seen that, go check out my videos. I literally walk you through all of the cases that talk about this specific issue. We go through everything, and I show you very clearly why, even though I still believe Karen Reed should have been acquitted completely, but with this specific issue, double jeopardy, she just it's not a winner. Lynn Riccio, why didn't Karen attorneys speak up? Are you talking about at the Supreme Court oral argument, or are you talking about during the trial? At the Supreme Court argument, you have to be qualified. You have to be go through a process in order that you're going to be the one to argue the motion, to argue at the hearing. So they could be there, they can attend, and this happens all the time. You have a lower case, you have something at the trial court level, and then you may appeal that, and the trial counsel will come along with the appeals, but they won't be the ones to argue the appeal. And a lot of times the appellate attorneys are better researched on the law. They're in a better position to argue the case. In this case, I believe I could have argued it better than Weinberg, but Jackson and United will still come along and watch. I just hope that Karen Reed didn't have to pay for them to come, because it's a complete waste. They could have seen the live stream just like you and I did. And just for the appearance of everyone being together on the same page, I don't know how much it costs to fly Alan Jackson in and all the hours that he's spending going, traveling and everything. So I don't know, maybe that was just on his own because he wanted to be there. But you're not allowed to speak up unless you've been okayed by the Supreme Court to argue this specific hearing. Your lawyer friend Denise, BC is nothing but thorough. Thank you. And if you are a lawyer, which your name suggests, then I appreciate that even more. So thank you. Now I said, yes, I watch all your videos. Yes, you should all watch my videos, especially on the Karen Reed case, because I don't think anyone's really done the research on the law like I have. I mean, if you really want to understand and not just be involved emotionally in the case, if you really want to actually understand what's going on, then you really have to have a good understanding of the law, which is exactly what we do on this channel. So. Okay, well, that's going to be it for now, because it doesn't seem like there's any more questions. If you have any other questions, put them in the chat right now before I sign off. But what I plan on doing is, again, more of a recap and more of a breakdown of what happened between the certain questions and the answers. I'll rewatch the entire oral argument between Marty Weinberg and the justices and the questions, and why I think some of the questions could have been answered better. We'll probably do a recap and some more analysis on that. So thank you all for joining the live stream, and yeah, definitely go replay it if you need to. I'm going to do it myself. I'm going to look at this again, and hopefully we'll put out another video today with the Karen Reed situation, and that'll be it. So please subscribe, like, and as always, thanks for joining. We will see you next time.